Good afternoon, both.
Hi.
Hello.
Hello.
Hello. Welcome, everyone. I might give it a couple of seconds and then we can get cracking, just in case there's a few latecomers. I think that might be a good idea. How are you both doing? Well?
We're
Fine,
fine,
thank
thank
you.
you.
Yeah.
I just love it
Great
when you
stuff.
wait for the stragglers, because it's like it's a cloud video platform thing. It's like, how can you be late? You're at home.
That's right. And talking about clouds, gosh, it's cold, isn't it, today? Incredibly. So here we are.
We were just saying about the illusion of the sun, but really it's between two
I
months.
do love that
Right.
winter sun. There's something special about the winter sun. If it's sort of, being a bit defiant, poking through, trying to melt the frost.
That's it.
For sure. Brilliant. I think I'll get started then. Welcome, everyone. Good afternoon to LAW2022 Online Family Law Shape the Debate, sponsored by Our Family Wizard with me, Tara Dunn, Safta Mahmood and Alyssa DaCosta Waldman. In this live session, you can put your questions to Alyssa and Safta and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, you should see a chat function. All questions are submitted in private, so please do ask away. And if you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. And a recording of today's live session will be sent out via email within the next few days, so please keep an eye out for this. So without further ado, I will get to some introductions. So as I mentioned, my name is Tara Dunn. I am the legal associate at Our Family Wizard, and my role includes introducing and educating judges, barristers, solicitors, and all family law professionals about our Family Wizard co-parenting platform, which offers divorced or separated parents a collection of tools to easily schedule parental responsibility, share important family information, manage expenses, whilst creating an accurate record of co-parenting communication. I travel around the country to attend and speak at family law conferences, workshops, and seminars every year. And before I worked for Our Family Wizard, I was a family law paralegal at a law firm in London before becoming a county court advocate presenting oral submissions in court on a range of civil law matters. I am delighted to have returned to the family law arena, working with courts, chambers, firms, CAFCAS, mediators, charities, and all other family law organisations to help parents with their communication. So let me introduce to you our wonderful speakers today. Firstly, we have Safta Mahmood. Safta has extensive experience in both practicing and teaching family and children law for over 27 years now. Safta practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children Law Accredited Scheme for approximately 20 years now and is both an assessor and an author, having written in various legal publications, including for the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. For today, as part of LAW2022 Online, Safta's session includes domestic abuse, key principles and developments, as well as principles of parental responsibility and the use of Section 8 orders in family law. And secondly, we've got the wonderful Alyssa DaCosta Waldman, who is a practicing barrister at New Court Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She is a regular speaker on legal topics and as well as an author. During her career, Alyssa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law, solely authored Everything You Wanted to Know About Practicing Family Law in 2004, and last year contributed the chapter on trust law to Resolution's cohabitation book. Alyssa encourages and practices non-court dispute resolution methods and is an experienced mediator, collaborative lawyer, and family law arbitrator. Thank you both for being here today. As part of LAW2022 Online, Alyssa's session will include qualified legal representatives appointed by the court, as well as financial remedy autumn roundup. So guys, to kick off today, we will start addressing some of the pre-submitted questions we have received from you. So to kick things off, Safta, this question is directed at yourself. So there seems to be a new service of Independent Custody Visiting Association, ICVA, to assist with contact matters in private law cases. Would you mind explaining where they fit in and whether there is any cost to the other parties?
Yeah, sure. Thank you for that. So ICFA, as it's referred to, it's a service that's only been used in some areas. It's put together by CAFCAS, and it's one of the various tools that they're using to ensure that they are, of course, doing what they should be doing in terms of ascertaining wishes and feelings, not just obviously of the child, but also gathering the necessary information when it comes to the welfare reports in terms of the Section 7 reports that we're getting ready for particularly private children or cases. So it's one of the various innovations that we're using to use other ways of being able to gather information, but more so specifically being able to refer to ICFA, as it's referred to, very early on in the proceedings. And what I would suggest is, for some of you who work in this area, is this ties in with the bigger picture, which is the private law working groups recommendations headed up by Mr. Justice Cobb. He and the group are very much working closely at revising Practice Direction 12B. So historically, many of you will know that we would have the FHEDRA, the First Hearing Dispute Resolution, about 4 to 5 or 6 weeks after issue. That hasn't always happened because obviously of court delays and sadly COVID, which, as you know, has got a lot to answer for. And this is where ICFA kind of fits in that regard, because it's a way of enabling CAFCAS to get involved at an earlier stage. You're looking at maybe putting together the SPIPs, the Separated Parenting Information Programs, gathering that information at the gatekeeping stage so that this could then be available for the court, either at that pre-hearing stage or indeed even at the FHEDRA stage. The cost for this, certainly from my experience, is being met by CAFCAS in this regard. So they're effectively providing this service in that regard. I mean, I know some of yourselves will have had experience of this where you're also referring this to other organisations as well. So Alyssa, is this something that you've come across? Have you used it so far?
No, and I'm glad you asked me that question, because I've got a couple of questions for you. I've just Googled it, and I mean, I've heard of ICFA, but my understanding was it was a volunteer that visits police stations.
Oh.
Right? That's my understanding.
Right.
What does an independent custody, because it's the Independent Custody Visitors Association, right? So,
right.
Yeah, so these are people that my understanding was they visit custody suites.
Actually, my apologies. Actually, you're right. I'm actually looking at the question. It seems to be, you've asked for ICFA, not ICFA. So that's my,
So that's my confusion.
Right, I see. Yeah.
ICFA, not
Oh, I see. That's right. To be honest, I didn't actually pick that up.
There's a difference, isn't there?
Yeah, that's right. That's right. So absolutely. Because
I've got another question and an observation. So what you're saying is this is not the custody people. This is the family people.
Yeah. That's right. That's right. So I'm actually
tell everybody what ICFA means.
Yeah, sure. Okay, because I don't know if the question is related to ICFA or ICVA. That's I suppose, because I must admit my experiences of ICFA, like I've just mentioned,
exactly,
which is
one is the custody suites at police stations.
That's right, and to be honest, I don't know much about that at all because I don't do police station stuff at all. So this is, what ICFA basically stands for is Improving Children Family Arrangements. That's what it is. It's the service that is put together by CAFCAS, like I say. Very different indeed. That's right. So I don't know if that is the question that was being asked, in fact. But this service is where, obviously, there will then be meetings between parents and obviously CAFCAS and children to help them to, firstly, gather together that information to enable them to spend that time together. But it's very much more direct work with the children. And what you're finding is also actually observing that, spending time with. So actually, you're observing what the relationship is like between the parent and the child, so that in turn the court can actually give that, or rather the CAFCAS officer can give that first-hand information to the court. But it's a service that CAFCAS have put together. It's delivered by them, They've got various service providers who will obviously work alongside this. And like I say, it does tie in with the private law working group insofar as that's concerned. But as you can imagine, it's limited. Not all areas across England and Wales are utilising this at the moment, and that's part of the problems you've got with the resources.
Can I jump in there?
Sure. Yeah.
Because I mean, that obviously I have heard of course, which is why I was like, got a bit confused, as maybe some of our audience were. It sounds to me, and this is a problem that comes up in my presentation of qualified legal representative, that here is a service that is provided by CAFCAS, but it sounds to me as if what CAFCAS are doing is they're subcontracting out to other organisations to provide something that ordinarily they would have been doing during the course of writing their reports. And I think you'll agree with me that one of the difficulties we have seen over the last few years, even before the pandemic, is that CAFCAS are oversubscribed and under-resourced and don't have the people power, the physical resources, the people to go out and do the reports in a time that is suitable for court proceedings. I have numerous proceedings where the court's ordered a CAFCAS report and the CAFCAS officer's writing and saying, sorry, can't get it done in time for your hearing. And then the hearing gets pushed back. And then that has an impact on status quo and what's going on with the children. So all of this creates a sort of domino effect of further difficulties. So it seems to me that this ICFA is a way of subcontracting work which would ordinarily and properly ought to be done by CAFCAS to other organisations, but CAFCAS is paying for it. The other thing that I would say, that in my QLR presentation, the qualified legal representatives, where we're talking about vulnerable people being cross-examined by someone other than the party who might be the perpetrator causing their vulnerability, if the court has to appoint the qualified legal representative, who pays for that? Her Majesty's Courts and Tribunal Service, right? That is paid for publicly. So we as the taxpayers are paying for all that one way or another. And the problem here is blindingly obvious, isn't it? Why is CAFCAS paying for your thing? Why is HMCTS paying for mine? Because there's no damn legal aid.
Yeah.
So what they've done by removing this terrible removal that we've all complained about of legal aid from people who desperately need it and should have it, is that you're just moving that expense elsewhere. But someone's still paying for it.
Yeah, no, you're absolutely right. You're absolutely right. And I mean, certainly with the qualified legal reps, which I know you're going to talk about, Alyssa, shortly. I mean, you're right. That's something that we've been, as practitioners, as professionals, this is something that we've been arguing for in terms of the funding for, I would say, best part of about 20 years. And, even Sir James Munby, the previous president, number of judgments that were handed down saying, we really need this. And there was an attempt on this in the previous, I think it was a Courts and Prisons bill. They even put a clause in there on it, and then they dropped it, sadly. And even now,
how are you going to fund it?
Yeah. And even now, the funding for it, because I initially thought that the funding was going to be equivalent to what it is in the criminal courts, but in fact, it's not. It's actually a lot lower than that. So even that, even though we have got some funding, it's still very limited. And I think I agree with you entirely.
You're not going to get, it's not going to, if that is the case that the funding is very low, then the difficulty is going to be incentivizing lawyers to be that qualified legal representative. So I'm not sure that all this legislation, all these great plans is going to solve that problem.
Yeah, I agree with you. And in fact, anecdotally, since that's been in place, and it's only been, since the 21st of July, so it's not that long. Anecdotally, not many lawyers have actually put their name forward on it to this stage. So again, there's going to be a question mark. That's right.
Yeah.
So there's going to be a question mark as to actually how effective it is. And sadly, it's the same with the ICFA process. You know, it's funded by CAFCAS, but it's limited, very, very limited in terms of resources. So that will have an impact on obviously what information there is, its reliability and its usefulness there. That's right.
Yeah.
Thank you both, and thank you for picking up on the. I think it must have been the author of the question intending ICFA. So thank you both for explaining that. That's very helpful.
Thank you.
The second question is also directed at you, Safta. So please do, Alyssa, chip in if you so wish. And the question is, who comes within the definition of associated persons under the Family Law Act 1996? And how is this different to the definition of those who are personally connected under the Domestic Abuse Act 2021?
Okay, I'll answer this one fairly quickly because I know it's quite a interesting point and a limited point. We've got Family Law Act, obviously Section 62, 63. You got your definition of associated persons. Some of the main ones are spouses, former spouses, cohabitees, former cohabitees, civil partners, former civil partners. You've also got a long list of relatives. You've got people who are or have been in an intimate personal relationship of significant duration, parties to the same family proceedings. Those are the main categories. The personally connected definition under the Section 2 of the new Act, the Domestic Abuse Act, is similar but different in the sense that, yes, it includes spouses, yes, it includes former spouses, civil partners, former civil partners. But there's two contrasting bits which I find interesting. One is they don't specifically mention cohabitees, which, again, Alyssa, from your experience, you know, as an expert in cohabitation, you're thinking, hang on a minute, exactly, it's supposed to be going that way, and it's kind of almost regressing in a way.
Yeah, and you know what I don't understand? The two bits of legislation, I would have thought that there would have been significant repeals of parts of the Family Law Act 1996 because of the Domestic Abuse Act and its definitions. And I would have thought that there would have been some continuity of definition. And I think I gave a presentation, not the same as yours, but on the same bits of legislation a while ago for Solicitor Group. And I think I highlighted at the time that there are contradictions between the two bits of legislation. We're not going to go into all of those now, but several contradictions that have not yet been resolved and should and need to be resolved. Very confusing to have the two bits of legislation running in parallel. There are some differences.
Absolutely. So, for example, you know, if I was going to court for, say, a non-molestation order, I've got to satisfy the associated person criteria. So if I'm relying upon somebody who is or has been in an intimate personal relationship, you know, say your boyfriend, girlfriend, not living together, but they have been intimate. If I'm using the associated persons definition, I've got to demonstrate significant duration. But the personally connected one.
How long is significant duration? What does that mean?
What does that mean? That's right. That's right. So that's always been subject to judicial discretion. But then the personally connected one doesn't even use duration anymore. It just simply says in an intimate. So again, you know, ultimately the judge will think, well, which bit of law do I use here? And like you say,
exactly. For the judge, what do you apply? Which one?
Yeah, that's right.
And just going back to significant duration, I mean, that is, who drafted this? What does it mean? It's very interesting because I met somebody last week who said, oh, I'm so-and-so's new partner. And I said, oh, that's lovely. And I said, how long have you been together? And she said, 3 months. Now, I would be very hesitant to call somebody a new partner if it had only been 3 months. And I'm not sure that I would regard 3 months as significant duration. I was quite fascinated by that. And I think not only do we have problems as lawyers with definitions, I mean, the word reasonable is like, oh, the bane of our lives. What's reasonable in any given situation? But, you know, the idea of I'm someone's partner after 3 months, do you think that's significant duration? I don't know.
It makes you wonder. Well, I mean, I suppose turning it on its side, what if you've got somebody who's been together for, say, just under a week, but there's a baby underway? Now they've been intimate.
I know. that can be a one-night stand.
Yeah, exactly.
You know.
So, but I suppose, there is that judicial discretion, I suppose, there, isn't there? And hopefully the judge will be persuaded more towards thinking, yes, I'm satisfied this is met, and hence I can go on and make the order. But yes, I think some certainty, some clarity on that would not go amiss, of course,
For sure.
the reasons you say. Good. Thank you for that.
Perfect. Thank you both for that. We will move swiftly to you, Alyssa, with regards to some finance questions. So the first of which is, how will the economic climate impact on financial cases?
Oh, that's a minefield. That is a minefield. Certainly, every time there is a downturn in the economy, and thanks, Liz Truss, for that. Every time there's a downturn, and particularly, it couldn't be worse right now, could it? The headlines, we're in the worst slump for like 40 years, cost of living, everything. The impact on financial cases is there is going to be a lot more debt. So rather than dividing assets, we're going to be looking at who's going to bear the debts. It will have an impact on house prices. It will have an impact on cost, the cost of living. And that's one of the reasons that I think the impact of the CGT changes that hopefully will come in next year, still in draft, but hopefully it's still going to come in, will help those people, particularly the separated, usually husbands, who've had to move out and have moved out for a long period of time, and under the current rules have to pay CGT on their share of the former matrimonial home, but in the future won't. That will help enormously. But if anybody out there thinks that a rapid or a significant reduction in the value of a home is a barter event, no, it won't be. Fluctuations in pensions, investment, shares, house values, these are not barter events, because a barter event is an unforeseen event. And right now, none of this is unforeseen. It's just bloody awful and unlucky. And we all have to deal with it. But I think, of course, it's going to have an impact on people paying legal fees. I am hopeful that the impact of the current economic climate on those thinking about divorce or cohabitants thinking about splitting up, I'm hopeful that the impact will be they will see sense and mediate and opt for non-court dispute resolution, because I think although that is not cheap, it is cheaper in the long run. And it also enables people to deal with their disputes in a more conciliatory fashion. I think it was fairly recently that our El Presidente of the family division, Andrew McFarlane, posted something either on Twitter or wherever to say, to sort of reiterate that mediation's the way forward. It doesn't have to be mediation. There's any number of ways of non-court dispute resolution. But we really should be encouraging that, partly because of the wretched backlog since the pandemic and before, and partly because, I did an FDA, a first appointment in a finance case a week ago, and our FDR is not till June next year.
Yeah, that's it.
Who in this economic climate wants to go through another 6-7 months of uncertainty when... if you put your sensible hat on and you think, let's share the cost of a private judge for a private FTR, they could resolve it a lot quicker. And simply by doing it earlier, before there's an even greater potential downturn, who knows, it's cheaper already because they've resolved it earlier. Yeah. So I think really difficult to predict total impact on financial proceedings of the current economic climate, but it's not going to help anybody. So we have to inject some common sense, I think, into our clients to offer them different ways of dealing with their disputes rather than going down the court route.
Alyssa, just as a side issue for me, thank you for that. That's really helpful. Just as a side, I know, we're very, very clear about the benefits of mediation, and I think you absolutely nailed that in terms of the importance of it. I know the president was emphasising that with the MIAMs that are there, of course, and have been in place for some years now. I know the president was saying at the recent family mediation conference whether MIAMs should also become mandatory for the proposed respondents as well, because at the moment, of course, it's for the applicant. If that did become a possibility, I mean, do you feel that if the proposed respondent doesn't turn up, do you think that should then be reflected in maybe cost orders to say, well, actually, we're not going to let you, claim your full costs? Or how do we make it compulsory for a respondent?
Well, I mean, this again is a minefield, Safta, because the whole point about mediation, or one of the important things about mediation, is it should be voluntary.
Yeah.
And then you've got, the list of exemptions in a MIAM, and many people will go to their MIAM, pay lip service to it, and ensure that they're one of the exemptions so they don't have to go to mediation. But the other side of that coin is that the courts, both civil courts, which are the Talata claims for cohabitants, and the family courts, are becoming increasingly willing to make cost orders against people who demonstrate an unwillingness to not necessarily mediate, but adopt any form of non-court dispute resolution. So I think it is to be encouraged. And, MIAM or not, or whether it's suitable or not for a MIAM, you can mediate a dispute where there are reasons that a MIAM is not suitable. You can. There are ways of doing it. You have shuttle mediation. I do mediations online. And if someone doesn't want to have their screen on, they don't have to.
Yeah, absolutely. There's so many different ways.
We can do it in real life, but in separate rooms. You can have hybrids where people have their solicitors present, which would make someone feel a lot safer and protected. There are many ways. Or, we don't even have to do mediation. You can negotiate an out-of-court settlement through correspondence, through legal representatives. The parties never have to be physically involved in that. So, there's any number of ways and means of dealing with this out of court, even in situations where there's a vulnerability and one party might not feel particularly safe in the presence of the other.
Yeah, fantastic.
That's great.
That's right. That's what it is. And we've had, I know we've had a couple of people who've said they've managed to successfully argue the intimate personal relationship, where the relationship was 3 months of significant duration. So you're absolutely spot on. So I think 3 months, so good. Well done. Well done. There we are.
Absolutely.
Excellent.
Brilliant. We will simmer back down to children cases for a moment, Safta, if I may. So we've got a question asking, what categories of applications are there for an occupation order?
All right, so this would be occupation orders done under the Family Law Act, and there are various categories. There's section 33, 35, 36, 37, 38. So that's what, 5, isn't there? Those are the various ones. The two main that we tend to use are 33 and 36. 33 is where somebody's got a right to occupy, basically. So if they've got the right to occupy the home, the dwelling house that was occupied or intended to be occupied as a family home, then you would apply under 33. So that would cover, for example, spouses, former spouses, civil partners, former civil partners. You've got people who are renting, who've got a beneficial interest, they've acquired that. And like say, if they're married or in a civil partnership, and if they own the house. But the other one, which I think is a really, really important one, tying in with, again, the cohabitation side, is section 36. And I think a lot of people are unaware of this. The idea that, let's say you got a man and lady who are together for, say, 3 months, for example. They're together, they have been cohabiting, house is in the bloke's name, lady moved in with him. They've been cohabiting, living together most days of the week. There's intimacy, there's some level of financial sharing of resources. If he gets difficult and say 3 months later she comes to you and seeks an occupation order, even though the house is not in her name, she can apply under 36. And I think that's really, really important to bear that in mind. I mean, there's still the criteria, there's the balance of harm, there's the criteria you've got to go through. But she can apply, and obviously it works exactly the same ways if the house was in his name and, in her name, and he's applying. So fantastic, really, really necessary innovation. Okay. So.
Great. Thank you so much, Safta. So, Alyssa, back to you. Just following up on the capital gains tax that you briefly mentioned, we've got a specific question here asking, should I be careful about the timing property transfers in light of the changes to capital gains?
Yeah, absolutely. So the changes that are planned so that the absent spouse can take advantage of their share of the matrimonial home being their PPR, principal private residence relief. They can get that. Think about, and the closer, of course, we get to the new year, the easier it is, because the changes will take effect the other side of the new financial year, so the 6th of April 2023. So certainly if there are going to be transfers or sales of homes or whatever, think about ensuring that that is not effective until the other side, so of 5th, 6th of April, so it's after the new financial year, and then the clients can take advantage of that and not have to pay whopping great amounts of CGT if they've been out of their matrimonial home for a significant amount of time.
Fantastic. And I mean, that's gonna reflect a lot in the consent orders that we draft thereafter, because at the moment we're having to provide for that, aren't we, to say if there is CGT, they're both should have, that's right.
The net sale, the gross sale proceeds is one of the factors, isn't it? Mortgage, selling costs, conveyancing costs, any CGT.
Fantastic.
And hopefully we can avoid that going forwards when the law changes. So I do think that's a really good thing. It recognises, and it stops penalising the spouse, because it's often somebody who's had to flee for domestic abuse reasons. So there's all sorts of vulnerabilities, both psychological, emotional, and financial for that person. So to almost penalise them with a whopping great CGT liability because they've been compelled to leave, it's dreadful. So not doing that now, I think, is a huge of huge significance.
Yeah, thank you.
Great, thank you. Great. So, Safta, back to you. We're going to be talking about personal protection orders. So the question for you is, what kind of situation may a personal protection order be made without notice?
Okay, so without notice, I know many lawyers out there, we still use the word ex parte, don't we? But as you know, it's, without notice. Section 45 of the Family Law Act, there's 3 categories there. The main one we often tend to use is if there is a risk of significant harm if the order were not made immediately. That tends to be where there's been recent abuse. There's a likelihood it may repeat itself. If we went for an on-notice hearing, even if we can get it listed, say, in the next couple of days, that may prejudice the applicant because he or she may be at that risk even at that period of the next day or two. But the other one, which I've used a few times, is the other one under 45.2, which is where your client may be deterred from applying if you don't go for the order without notice. And I find that's quite useful. When I've spoken to victims of abuse and I'm saying to them, right, the procedure is we're going to get it uploaded or sent an email to a court. We're then going to have to get your ex-partner personally served. That's when they panic. They think, my goodness, you're going to tell him or you or her that I want this order against them. Well, in that case, I don't want to go for it, because the moment they find out, all hell is going to break loose, and they're going to cause massive problems. And that's where you may want to go without notice. As soon as they're served, of course, the protection's in place straight away. So those are the 2. There's another one, which is if they keep deliberately evading service. We tend not to use that one as often, but it's there as well. Okay.
I'm just going to jump in there.
Sure.
Because, and this is really directed to our solicitor friends out there. If you are going to go without notice, you must say in your supporting statement why you're doing that, because not to do that could be fatal to the application. And the other thing is that in most cases, the court will expect there to be short informal notice. So without notice is it's almost frowned upon. And the court, in my experience, Saf, so please correct me if I'm wrong, but in my experience, the court tends to expect the short informal notice rather than none at all.
That's absolutely spot on. That's absolutely spot on. In fact, I would go as far as saying that, as Mr. Justice Mostyn said, there's one of the leading cases is the VW ones back in 2016. And one of the things emphasised in there was without notice orders are the exception and not the norm. So you're absolutely spot on. Even, I mean, I've had it where we've literally given about an hour or two's notice. As long as we tell them, look, I'm going to court, gives them time to go and think about it, get some legal advice, and then we go to court and hear it. Always the better option if you can.
Yeah, but obviously there will be those cases where the fear of the reprisals, having done it, actually do merit a without notice. But they are, as you say, they are the exception rather than the rule.
Yeah, that's right.
Yeah.
Thank you.
Great. Thank you both. Alyssa, we're going to go back to capital gains tax for a moment. And if you could just tell our delegates what the changes to capital gains tax from the financial next financial year are.
Well, I think as I've already alluded, the changes are that, and it really is about getting a court order. It's not just, whoa, any married couple, someone has left and gone elsewhere, can now treat their, if they've been out for a significant amount of time, they can now treat their former matrimonial home as their principal private residence, even though they've been absent. That is a significant change. But in order to, I think the most important thing is that in order to take advantage of that, you have to have a court order in your divorce proceedings, a financial remedy order. You can't just say, well, I've been out for 3 years, it's being sold, I want I don't have to pay CGT, do I? The change is relevant. You only really receive it if you have a court order to demonstrate to the tax people that you don't have to pay CGT because it's part of a court order. So I think that is the most significant change.
Alyssa, what's really quite ironic is the timing of this, because of course, they're bringing it in, probably 6th of April next year, in line with, the other. And of course, the recession we're going through, one of the worst. And yet, prices are going down. Prices are going down. And, is there going to be CGT? Makes you wonder, doesn't it?
I mean, it depends, doesn't it? It depends on the value of the property. It depends on how much they're going to go down. What I have noticed, which I think is quite good, and I've been seeing it in the news today, is that because one of the big problems I'm noticing also, and you've just reminded me, in matrimonial cases, is when you're getting a mortgage capacity report. I've got so many clients that pre all the troubles might have had a mortgage capacity, but now because of the interest rates, they can't get mortgages in their own right, and that's creating a problem. But I have seen in the news today, and I know this wasn't your question, but I think it's good to point it out. I've seen in the news today that mortgage rates are starting to go down a little from where they were a couple of weeks ago. So I think that's a move in the right direction, because the other thing is what we can't have a stagnating housing market, because that is going to, and that's one of the impacts of the recession, I think, force people who might otherwise want to be divorced and live separately from each other to stay together in a situation which is only going to increase the domestic abuse orders if they're forced to stay together.
Absolutely. And with the mortgage earning capacity report, which is, like you say, what people would have got before the mini budget is different to what it is now. And I know certainly some lawyers have gone as far as saying that some of the mortgage companies, what they're doing is they're saying, fine, we'll give you a mortgage earning capacity report, but it's only valid for the next 2 weeks or something, because we don't know what's going to happen to interest rates.
Yeah,
They may go up again. And
yeah, and they're normally valid for 3 months.
Yeah, that's right. That's right. So
it
does kind of make
Hobbs, we're back to 3 months again.
That's right. So it does make you question, the reliability and usefulness of it. That's right.
Yeah.
Thank you.
Yeah.
Brilliant. Thank you so much, guys. Sorry, Lisa, did you have
I'm going to shut up now.
We're going to go back to occupation orders, Safda. So would you mind telling our audience when the court can attach a power of arrest to an occupation order?
Okay, sure. And I think the importance with this question is, when would the court attach it to an occupation order? Because, of course, even now, so many lawyers in practice make the mistake of thinking that they need to be formally applying for a power of arrest to a non-molestation order. And you don't need to, of course. Section 42A has been enforced now since July 2007. If you get your non-mol, you get your power of arrest. With your occupation order, it's basically Section 47 of the Act. You've got to be able to show that there's been violence or threats of violence, unless the judge feels that the applicant and or relevant child would otherwise be protected. There is, interestingly, a slight distinction in that if it's made without notice, then the court has a discretion, whereas if it's made on notice, then Section 47 says the court shall attach the power of arrest, like say if there's violence or threats of violence, unless they feel the applicant and then your child will be otherwise adequately protected. So it's a bit of a, yes, grant the order, but actually it's a bit of a get out as well, which is, if I feel they'll be adequately protected, I'm not going to touch it. So it's a bit of an interesting test, actually, which a judge will apply. My experience is, whenever there's physical abuse or evidence of, I've nearly always got the power of arrest attached. I think experience normally dictates it will be attached, because the benefits of it obviously are highly necessary. Okay.
Well, that's really helpful. Thank you, Safda. Okay. Brilliant. So we're going to go to a specific case law question now, Alyssa. And the question from one of our delegates, which was pre-submitted, was, what did Udin decide about the proper way to conduct financial remedy proceedings?
Yeah, Udin was a really interesting case. You would have read it in my presentation. And as well as all the regular assets of the marriage, the reason I like this case particularly, very good judge, Stephen Wildblood, who is author, I think he's a KC, is very, very good and very sensible judge. I like this case because it sort of straddles both financial remedies and tolata, because there were two properties involved in the case that were not the matrimonial home, and they were dealt with under tolata principles. But it was blindingly obvious very early on that the wife's claims about those properties had no basis in law, absolutely none. And there was very little evidence to support the case that she was presenting. So when the court got to the end of this, there was a bit of a tirade, a bit of a rant from His Honour Judge Wildblood, who said, this is not the way to run these cases. And he said, he criticised the wife's solicitors particularly, the manner in which the trusts issue on those two properties had been presented. And he said the authorities, which would have been Stack and Dowden, Lascar, Mar and Colley, the usual suspects, he said all of those, they were relevant authorities, but they had either been misquoted, and I just think, how do you do that? Or they hadn't been put before the court at all. So that is not the way to run a case. And he said that there had been a delay and there had been an escalation in the proceedings. And to quote him, he said that was entirely attributable to the failure of both parties to comply with directions, to engage meaningfully in attempts to settle with open offers. And he said also the wife's dogmatic pursuit of the speculative and unprincipled trust claims. So the Talata element was totally without merit and should never have been pursued. The judge also said that the husband had been dishonest in his presentation of his financial position. And that actually, I mean, so all of these things add up to how not to run a finance case, right? What not to do. And very often we see the how to do it well by looking at how not to do it when cases go wrong, when people are criticised. But I just want to say, because I'm looking at the time, we don't have huge amounts of time, that I just want to refer to the husband's dishonest presentation of his financial position, because I've also, in the presentation that people would have seen before, cited His Honour Judge Hess's decision in X and Y. And I just want to highlight something that is happening regularly now. That was a case where the husband presented a situation to the wife that was totally untrue. And the reason he was able to do that was because of various free apps out there that enable people to doctor bank statements. And this is a huge problem now.
Yeah.
That people, you can provide your disclosure with your Form E, but someone's already doctored it using a free app. Now, unfortunately, we as the legal representatives, I've never thought it was part of our job to receive the bank statements and, while analysing them, look at the metadata to see whether someone's fiddled with it. It's not really our job, nor should our clients be put to the expense of paying for that. But it's a growing problem.
Yeah, you're right.
Fake documents, not fake news, fake documents. So we need to be alert to it.
Absolutely. I mean, there was a children case on it a few years ago, I recall, where dad had testing done to determine cannabis heroin usage, and he was a litigant in person, so he instructed company, and he got the results. They said it's positive. He didn't like the outcome, so he decided to download, I think it was PDF Acrobat, and he decided to manipulate it and change it to not negative, and decided to file that. The judge was very close to doing him for contempt and sending him down, but I think he'd already paid his price at that stage. So you're absolutely right. There's more and more of that going on now, isn't there? People are really pushing the limits, aren't they? And you're right, there is a question mark as to how far as lawyers are we expected to go behind those documents. Should we be expected to? It's a very, very good question.
I don't think we should. I mean, that is the sort of forensic exercise for an expert, isn't it? It's like, years ago, if you thought something was a forgery, you get the old handwriting expert. And of course, now there is a degree of sophistication in how documents are produced and disclosed, and therefore there's a sort of matching degree of sophistication in what people can do to mess about with them.
Yeah, that's right.
Alyssa, is so scary.
That's right. Alyssa, can I just as a side question, if I may, and I know time's obviously ticking, but in terms of cohabitation, I know one of the big cases earlier this year was the Hudson and Hathaway decision about this whole issue about common intention and how later a common intention can vary the initial acquisition of the property as joint tenants. I mean, what's your view on that? Because isn't it going a bit too far, would you say, that actually just by emails that they've exchanged between themselves, that could actually vary a beneficial interest? Do you feel it's taking Stack and Dowden too far?
We know. Well, I mean, we know from Stack and Dowden, and and Jones and Kernock together, that together they drove a coach and horses through the previous law, I think, on the variation of trusts, because prior to that, a variation of trust had to be evidenced in writing. So the question that you're saying, Hudson and Hathaway, is, all right, so what counts as evidence in writing? And the thing is, I mean, I'm always reminded, the the law is dynamic. The law is not, it doesn't stagnate. And the law has to, that's what we love about the law, that it is dynamic, that it has to adapt to changing social circumstances. And an email, we accept service by email. We do everything by email these days. So the law has to adapt, much as we may not like it, to those changing circumstances. And if you can show evidence of a change of intention via emails, well, in a sense, that is evidencing a variation of the trust in writing, isn't it? So even if we don't like it, we go, that's far too modern, we can't have that. It's how it is, isn't it?
Yeah, absolutely.
So sure that we can, whatever our views may be, that's how it is. And I do think, if you're looking at did the common intention change? And, there's already an accommodation of that, an acceptance of that in Stack and Dowden and Jones and Kernot, that if circumstances change, then clearly people's intentions as to what was to happen to the property or the shares in the property can change. So you've got to look at where's the evidence of that. And if the evidence is in writing and that happens to be an email, then so be it.
Yeah.
So there's lots of things I don't like about the modern way we do things. Don't get me on the portal. Don't get me on that one.
Absolutely.
It's a huge problem. Yeah.
Thank you.
That's a whole other can of worms.
Thanks for your question, because I appreciate that. That was a good one. Thanks.
Thank you.
Perfect. So going back to you, Safta, we've got a pre-submitted question asking, what is the position with criminal enforcement of a non-molestation order?
All right. So this really just ties in with the other question that we had. So this is the section 42A of the Family Law Act. So if you are getting a non-mol, you're basically got your power of arrest to that. So if somebody was to allegedly go and breach the non-mol, for example, section 42A allows the police to arrest without the need for a warrant if they suspect that the person has breached or is in the process of breaching or has already, like I say, breached the non-mol. They can take them through the criminal court. You've got summary conviction, you've got conviction on indictment. Maximum penalty on indictment is 5 years maximum, and fine. And CPS policies, they will prosecute, particularly if it's a domestic situation, they will prosecute in those circumstances. So what it has meant for us as family practitioners is we've been doing a lot less committals. I used to enjoy wearing the gown when I could, and the robes, but sadly I don't get that opportunity as often anymore as a solicitor. So it's a bit of a shame. But there we are. So therefore, we won't be going down the committal route in the family court as often for breach of non-mols. We're relying very much on the police taking it through the criminal route. Okay.
Perfect. Thank you, Safta. We've just got time for one last question. So, Alyssa, I'm going to direct this to you, which is, why did the late Mrs. Goodyear's death impact on the pension sharing order in the way that it did?
Okay, so originally, poor old Mrs. Goodyear, she acquired, in their financial dispute, 51% pension sharing order. The husband appealed because the usual provisions in the consent order that enable, if someone dies before the pension vests, if you don't put the particular wording, the pension just disappears into the ether. The person who has transferred the share doesn't get it back in the event of the death of the other person automatically. So there's a certain form of words that has to go into the order permitting an application to vary, set aside or appeal it, etc., with the consent of the personal representatives of the person who's died. That standard wording was not in this consent order. The court held, I think quite rightly, that all it does is confirm that the personal representatives will consent to that application, but not to the setting aside of the pension sharing order. So the husband appeals it, and he says this is a barter event, that she died because no one was expecting her to die. He did question, poor old Mrs. Goodyear had a cancer diagnosis, but after the settlement, I think he said she didn't disclose it till they got the settlement agreed, but she was only diagnosed fairly recently in comparison to when they'd agreed their order. And sadly, she died before the pension sharing order was implemented. The difficulty was Is it a barter event? Well, yeah, the court, I think, rightly held that it was, because she was, at the time of the consent order, she certainly wasn't expecting to die. She was expecting to make use of her pension sharing order. Was it appropriate? There was an argument by those for the wife that, well, why shouldn't she keep her pension sharing order? And I think the sensible answer is, what's the point of a pension sharing order? It's there mainly, although there's sort of 25% lump sum, 75% of a pension is there to create an income stream in retirement. Well, sadly for Mrs. Goodyear, if she didn't survive, she didn't need the income in retirement, did she? So what the court decided was, yes, her death was a barter event. Yes, they needed to vary the 51%. So in the event, her estate got 25%, which I think is probably fair. I think it's fair. Yeah, and it's, you know, it's a shame. And I think the case clarified that the standard wording confirms the personal representative's consent and nothing else. And I think that's sensible. And I think, you know, when you get these decisions, it's good to see that you've got judges that are operating from a premise of common sense rather than, you know, so they sort of, if I may say, they sort of massage the legal principles to arrive at a common sense decision. And I think that was one.
Yeah, definitely made sense, didn't it? Absolutely.
Yeah, it's sad, you know, that she didn't live long enough to enjoy the pension.
Yeah, that's right.
Yeah, cool. Well, thank you so much, Alyssa, for concluding very nicely on that point. Unfortunately, both, that is all we have time for today. Thank you to all the delegates that have attended today to watch Law 2022 Online Family Law Shape the Debate, hosted by our family wizard. Thank you to you both. Thank you to our expert speakers, Safta Mahmood and Alyssa Da Costa Waldman. For all our delegates who are watching, don't forget to join the solicitors group Law 2022 Online community on LinkedIn to continue the debate after this live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content. Your expiry date will be displayed next year and next to the webinar, and there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. You can also visit our exhibitor profile for more information on our family wizard. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. So thank you both again, and thank you for everyone for joining today, and hopefully see you again soon. Have a great day, everyone. Take care.
Thank you. Bye. Bye then.